All right.
All right, thank you. Please be seated. All right, can the interpreter hear me?
Yes, good afternoon.
Good afternoon. Do you have your copy of the Victims' Rights Advisement ready to go?
For the interpreter, Your Honor?
Yes, because they're making us read it now here. It's not statutorily required, but we've been asked to. And so I have Spanish speakers, and I was told that if you guys are in the meeting, you have to say what I say. So I'd asked if they have the Victims' Right. You don't have
Your
it?
Honor.
You do?
I don't have it, but I don't need it as long as I can follow the court. Thank you.
Well, yeah, no, it's just a lot faster if I do it all at once and then you guys do it all at once. Sorry, I'm not logged in yet. Are you a full-time interpreter?
Yes, Your Honor, I'm staff.
Okay, great. Then what I'm going to do, I got to send Mayela, I think, an email and say, can you make sure everybody's got it ready to go? Because we have to do it now. It's going to happen all the time, and it's just so much faster. So I'm not mad. I just was letting you know.
I can do it by paragraphs, Your Honor.
Okay, you're saying you can take a lot at once?
Yes, Your Honor.
Okay, all right, understood. Okay, that's helpful. Thank you. I'll try to, because this is one hilariously long run-on sentence and then a shorter one. So, all right, maybe I stop halfway through. Okay, here we go. This is the 2 p.m. calendar for November 20th, 2025.
Esta es la lista de causa de las 2 de la tarde del 20 de noviembre del 2025.
The court's orders for the taking of fingerprints and DNA samples made on the 2 a.m. calendar on the 1st of the month will also apply to these hearings.
La orden del 1 del mes para la toma de huellas dactilares y muestras de ADN aplicarán a todas las audiencias de hoy.
Before we begin, I'm going to read the Victims' Rights Advisement for any victims who may be listening online or here at the jail.
Aparte voy a leer la notificación para víctimas en este momento, para cualquier víctima que esté presente, ya sea físicamente o virtualmente en el video.
If you are the victim of a crime with a case pending before this court, you are advised that you have rights under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity. Stop there.
Si son víctimas de un delito y son la parte ofendida, se les informa que, de acuerdo a las leyes de Arizona, tienen el derecho a que se les trate con respeto, dignidad y justicia.
The right to a speedy trial, to be present at all court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, and the right to be heard before the court makes a decision on release, negotiation of a plea, scheduling and sentencing, and to receive restitution from a person who is convicted of causing you loss.
También se les informa que tienen derecho a estar presentes para cualquier juicio oral, que pueden ventilar.
If you have not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office.
I'm sorry, Your Honor, I froze halfway. If I could just get the court to repeat, like, just the beginning of the first sentence. Just the beginning.
Oh, if you have not already been provided? No. You mean, okay, so
the middle.
It was, okay, geez. You have the right to a speedy trial, to be present at court proceedings. Okay.
Thank you, Your Honor. Tienen derecho a un juicio oral oportuno, a estar presente en cualquier diligencia del tribunal. Tienen derecho a negarse o autorizar que los entreviste el acusado o el abogado representante del acusado. Tienen derecho a ventilar ante el juez antes de que se tomen decisiones sobre la libertad o no de la persona acusada, negociación de un convenio resolutorio, horarios y la imposición de pena. Si no se les ha dado directamente una copia de estos derechos que tienen como víctimas, por favor comuníquense a la oficina de fiscalía para que les entreguen una copia escrita. Thank you, Your Honor.
Okay. All right, and we're going to get that gentleman up here right now. Mr. Peralta, you come to the podium, please.
¿Puedo poner esto aquí abajo?
All right. Good morning, I'm sorry, good afternoon, sir. May I have your full name and date of birth? Oh, we
Juan Carlos.
I'm sorry. I apologize. I did not mean to interrupt. I was forgetting you had the headphones on. Okay, I'm sorry. Go ahead for the interpreter.
Diga, señor.
Juan Carlos Castro Peralta.
Juan Carlos Castro Peralta. Fecha de nacimiento.
28 diciembre 95.
December 28th, 95. Maite Lopez, court interpreter.
All right, thank you. I'm going to want to reprint to get his full name correct on there because he has no arrest history. All right, sir, and you said December 28 of 95?
Yes.
All right.
Trato, pero no lo entiendo muchas palabras, no.
I try English, but there's a lot of words I don't
Yeah,
understand.
I work in my English, but I don't know English good.
Sir.
Sorry.
If you're going to use the interpreter, please speak in Spanish and allow her to translate.
Sí, está bien.
Okay, now
Yes,
please,
that's-
what were you trying to tell me?
No, I te estoy escuchando.
No, I'm just listening.
Okay, you were arrested on 3 allegations that are as follows. Possession of dangerous drugs for sale, a Class 2 felony. 2 allegations of possession of narcotic drugs for sale as Class 2 felonies. For purposes of this hearing only, the court finds probable cause for the dangerous drug allegation only, not the narcotic drug allegations, because the police did not provide enough information regarding the alleged narcotics for the court to find probable cause. It does not mean that the narcotic allegations are dismissed. It means I'm not considering them when determining release conditions, only the dangerous drugs. All right. I am appointing a lawyer for you, and your lawyer can explain more to you about how that works, but you are still being accused of the narcotics in addition to the dangerous drugs. Your next court hearing will be a status conference on November 26th, which is this Wednesday at 8:30 in the morning in the downtown Superior Court. Your preliminary hearing will be December 1st at 8:30 in the same court, and that address will be on your paperwork. Based on the amount of methamphetamine it is alleged you were trafficking in, the court sets bail in your case in the amount of $100,000. It is cash only. If you deposit that with the court, you will be released while you wait for your trial in this case. If you miss a court date or violate your release conditions, then you will not get that money back at the end of the case, and there will be a warrant issued for your arrest. Your release conditions are all in writing, and they include no contact with the officers who arrested you, no contact with any co-defendants, no weapons, no drugs without a valid prescription, and you may not leave the state of Arizona without the court's prior permission. Everything will be on your paperwork. If you step to your left, we're going to get you a copy of that. Thank you. You've got that.
¿Sería todo?
Is that it then?
Yes, for today. You'll be back in court next week.
Gracias, le agradezco.
Thank you.
All right. And if the interpreter could make a general call, I think that is our only customer today.
Yes, Your Honor. ¿Hay alguna otra persona que necesite ayuda en español? Si necesita ayuda en español, informe, levante la mano.
Okay, I don't think we have any hands. Do you see any hands, officer? No, looks like we're good. Thank you so much. Have a great day. Oh, I'm sorry. He says he has a question. Go ahead. Can we come over here, sir?
Oh,
All right, go ahead.
Diga,
Sir.
señor.
Señorita, disculpe, lo que pasa es que no he podido comunicar con nadie del exterior. No hay manera de poderme ayudar a mí en algo, poderme comunicar. No tengo ningún
I'm
número
sorry, ma'am.
telefónico que sepa.
I'm sorry, ma'am. It's just that I haven't been able to contact anyone from the outside because I don't have any of the numbers. Is there any way anybody can help me to contact someone?
That's not anything that the court can help you with. Sometimes bail bond companies will make a three-way call for you if you call them collect, and you can connect them with somebody who might post a bail for you. They may be willing to try to contact someone on your behalf. That is a suggestion that I heard from detention officers in the past. I'm not aware of any other sort of tips to offer. But many people end up in that position because nobody memorizes telephone numbers anymore. Anyway. All right, if you step to the left,
Yeah.
they give you a picture. Thank you.
Okay, thank you.
All right, thank you so much to the interpreter. Have a great day.
Thank you, Your Honor. Likewise.
All right, Mr. Dasher, if you please come to the podium. Jameson Dasher. After that, it'll be Joel Derivois. Will you please go to the chair? You'll be after Mr. Dasher. There's a chair just inside the door. If you wait right there, you'll be next. Hi, Mr. Dasher. Can I have your full name and your date of birth?
Jameson Adrian Dasher, 12/28/1978.
All right, thank you. Mr. Dasher, you've been arrested on right there on your side of the door? Yeah, right there. Thank you. All right, Mr. Dasher, you've been arrested on 3 allegations. The first one is aiming a laser at an occupied aircraft, which when there's probable cause to believe that it caused the pilot to not be able to safely operate the aircraft for any period of time, is a Class 3 felony, and that is what the court finds probable cause for, as a Class 3 felony. Also, narcotic drug possession, a Class 4 felony, and drug paraphernalia possession, a Class 6 felony. There is probable cause for all of those, and I am appointing a lawyer for you. Your next court date is a status conference, November 26th at 8:30 in the morning in the downtown Superior Court, with a preliminary hearing December 1st at 8:30. The court address is on your paperwork. You have a $25,000 secured appearance bond in this case, and written conditions that do include calling your parole officer within 24 hours if you do post bond and get released. At this point in time, I don't think DOC has decided whether they are placing a hold on you at the jail. I don't know how much parole you had left. It's up to DOC whether they put a hold on you. You should check before you go posting the bond, because if they did put a hold on you, posting bond is not going to get you released. So everything's going to be on your paperwork.
Sure. Any way I can plead with the court to possibly lower the bond, please?
No, sir. In fact, the state recommended a $60,000 bond based on it being a police helicopter and you having 9 prior felony convictions and literally being on parole. So I don't believe $60,000 is required, but the court believes that with that criminal history, a significant bail is required. Plus the being on parole, which the court takes very seriously, whether DOC puts a hold on you or not. That does not work in your favor. If you step to your left, you get a copy of your paperwork.
Sure.
All right, Mr. Derivois, and after that, Nora Enfield. Will you go to the chair? Hello, sir. May I have your full name and your date of birth?
It's Joel Derivois, 10/25/1984.
All right, thank you. You're here on a new case. You were arrested for aggravated assault with a deadly weapon or dangerous instrument. That's a Class 3 felony. Also, simple assault as a Class 1 misdemeanor. There is probable cause for both of those, and I am appointing a lawyer for you. Your next court date is a status conference, November 26th at 8:30 in the morning, which is this Wednesday, with a preliminary hearing December 1st. Those will be in the downtown Superior Court, both at 8:30 in the morning, and that address will be on your paperwork. Your bond is $15,000 plus an ankle monitor if you post it. That is a secured appearance bond. If you post bond, you go on the ankle monitor, you may not return to the scene of the alleged crimes. You can't live there. If you were, you can do a civil standby to collect belongings if you need to. Absolutely no contact with the alleged victim. Don't respond to any contact from her. No weapons, no drugs without a valid prescription. Everything else is going to be on your paperwork. If you step to your left, they'll give you a copy. Thank you. It's Enfield, Nora Enfield. And then John Simmons, will you go to the chair? Hello, ma'am. Can I have your full name and your date of birth, please?
Nora Enfield, 030402.
Thank you. You're hearing a new case. You were arrested for 2 counts of aggravated assault on a minor. Those are both Class 6 felonies. Second-degree burglary, a Class 3 felony. Criminal damage, a Class 1 misdemeanor. 2 counts of assault as Class 1 misdemeanors. 2 counts of threatening and intimidating as Class 1 misdemeanors. And 2 counts of disorderly conduct as Class 1 misdemeanors. There is probable cause for all of those crimes, and I am appointing a lawyer to represent you. Your next court date will be a status conference November 26th, which is this Wednesday at 8:30 in the morning in the downtown Superior Court, with a preliminary hearing December 1st at 8:30 in the same court. Your bond is $2,500. It is secured. If you post it, you'll be reporting to pretrial services for alcohol testing and monitoring. I'm not going to make you wear an ankle monitor because it does not appear that you have any connection with these alleged victims, but you may have absolutely no contact with them. You may not go to that location. You will alcohol test to prove that you're not drinking, no weapons, no drugs without a valid prescription, no alcohol. If you'll step to your left, I'll give you your paper.
I have a question. What if you can't postpone?
Say it again.
What if you can't postpone the bond?
Then you stay in custody at least until your next court date. You can talk to your lawyer about it at your next court date.
Okay.
All right, Mr. Simmons, John Simmons. After that, Martin Chavez Gonzalez. Will you please go to the chair? Hi, sir. Can I have your full name and your date of birth?
John Albert Simmons, Jr.,
What's your date of birth, sir?
5276.
Okay, thanks. You're here on 3 things. 1 is a new arrest, and 2 are warrants from Gila County. I'm going to start with your new arrest here in Maricopa County. You are accused of organized retail theft of merchandise. It's a Class 4 felony. It means shoplifting with the intent to sell it for money. There's several ways to commit that crime. One of them is shoplifting something with the intent to resell it. It's a Class 4 felony. There is probable cause, and I am appointing a lawyer to represent you. Your next court date in this case will be next Wednesday, November 26th, 8:30 in the morning in the downtown Superior Court, with a preliminary hearing December 1st at 8:30. The court address will be on your paperwork. You are also here on 2 warrants from Gila County. In the first case, I'm going to sneeze, hold on, or not. Okay. In the first case, which is number, what is the problem here? Sorry, lost my mouse cursor. Okay, number 1 on the calendar. You've been charged with possession of narcotic drugs or equipment, narcotic drugs, and drug paraphernalia. Those are both felonies. This warrant issued September 23rd of 2025 out of the Gila County Superior Court. And so I'm going to put that together with your other Gila County warrant for a court date. And so in your other warrant, it's number 2 on the calendar. This one issued the same day, September 23rd, 2025. In this one, it is a failure to appear warrant in another drug possession case, also a felony. So your next court date for both of those Gila County cases is scheduled for November 25th, which is this Tuesday at 8:30 in the morning in the Gila County Superior Court. The address will be on your paperwork. And I'm just going to affirm the bonds set by the Gila County judge. In number 2 on the calendar, which is the failure to appear warrant, that's a $1,000 secured appearance bond. In the narcotic drug case, that's a $500 secured appearance bond. In the new Maricopa case, you have a $1,000 secured appearance bond. So that is $2,500 total with written release conditions in every case if you do post bond. If you don't post bond, they'll end up holding you here in Maricopa County until your Maricopa case is finished, and then they'll let Gila County have you. All right, if you step to your left, he's going to give you your paperwork. All right, Mr. Chavez Gonzalez, will you come to the podium after that? Brianna Minhares, will you please go to the chair? Okay, sorry, something just got messed up under the desk. All right, sir, can I have your full name and your date of birth?
Martin Chavez Gonzalez, 7/21/86.
Okay, thanks. You're here on a probation violation warrant. One second. Yeah. Oh, yeah. Yeah. Oh, shoot. Freaked out. No, I'll save them anyway. Not for him, but you know. Thank you. Sorry, I just don't want to scum up the mouse with that either. Because we all track things from back in the tank up here. All right, apologies, Mr. Chavez. I just needed to de-germ that for a second. Okay. You're Mr. Chavez Gonzalez.
Yes.
Okay, sorry. You have my full attention now. You're on a new case and 2 probation warrants. In the new case, you were arrested for possession of narcotic drugs, a Class 4 felony, possession of drug paraphernalia, a Class 6 felony, and criminal trespass in the 3rd degree, which is a Class 3 misdemeanor. There is probable cause for all of those things, and I am appointing a lawyer for you. And you're also here on 2 probation warrants. You are on probation for 2 felony cases, and you failed to appear at a revocation arraignment back on June 16th of this year, and a warrant was issued for your arrest. So I'm going to give you, looks like I can't give you the same next court date for both right now, but they should eventually come together in the system. So in the brand new case, the narcotic drugs and trespassing, that is going to have a status conference on Wednesday, November 26th at 8:30 in the morning, with your preliminary hearing set for Monday, December 1st at 8:30 in the morning. The address for that court will be on your paperwork. Then on Tuesday, the 25th of November, this Tuesday at 8:30 in the morning, is your probation court date. And that's a revocation arraignment and possible disposition hearing in the downtown probation court. In each of your 2 probation cases, you have a $1,000 secured appearance bond. In your new case, you have a $500 secured appearance bond. You have written release conditions in every case that do include calling your PO if you bond out. So it's $2,500 total. Everything you need to know is on your paperwork. If you step to your left, I'll give you a copy. Thank you. Ms. Minaharas, and then after that, Stevie Johnson. We go to the chair. Hello, ma'am. Can I have your full name and your date of birth, please?
Yeah, 04/22/92.
Are you Brianna Dominique Minaharas?
Yes.
Okay, thanks. You're here on 1 new case, and 2 probation cases. In your new case, you were booked in for theft of a means of transportation, a Class 3 felony. There's probable cause for it, which is not a high standard, and the police have met it. That's not the standard for conviction. It's just probable cause. So you can talk to your lawyer about that. I am giving you a lawyer in this case and in both of your probation cases. You're on probation for 2 Class 6 felonies, and the probation department will be filing petitions to revoke your probation in both cases based on this new arrest. So you'll have a lawyer for everything. Your next court date in the new case will be this Wednesday, November 26th at 8:30 in the morning, with a preliminary hearing Monday, December 1st at 8:30. Those will be in the downtown Superior Court, and the address is on your paperwork. Okay. In your 2 probation cases, you will go to probation court this Tuesday, November 25th at 8:30 in the morning. That's a revocation arraignment and possible disposition hearing. The court addresses are on your paperwork. In the new case, your bond is $1,000 secured. In each of the probation cases, it is $500 secured. That is $2,000 total. If you bond out, comply with all of your written conditions, particularly no contact with the alleged victim in the theft of means case, do not return to the scene of the alleged crime. Everything's on your paperwork.
So the victim, well, he says he's the victim. He actually gave false information to the police.
And that is something you can definitely assert through your lawyer to the trial court. Right now, the police are asserting that he told them that, which is sufficient for probable cause.
Yes.
This court does not determine whether someone was lying to the police. That is basically a factual question for the trial phase. I test whether the police have met the minimum standard for probable cause. They relate that he says he absolutely did not give you permission, and that is sufficient for probable cause.
And he actually did give me permission. He gave me the okay to go and take his keys.
And you can argue that through your lawyer. That does not defeat probable cause.
Okay. I just wanted to make it clear and put it out there that he gave false information.
You're allowed to defend this case and say that is not right, that is not true. You are allowed to do that.
Yes, because it's not true.
Okay, all right.
So,
if you step to that, you get your paperwork.
Thank you, Judge.
Then Stevie Johnson.
Okay. Thank you.
Good luck, ma'am. Then Cole Critchfield. Cole Critchfield, will you go to the chair? Right here.
Good afternoon.
Hello, may I have your full name and date of birth, please?
Stevie Johnson, 8/29/98.
All right, thank you. You are here on 2 warrants for failing to appear at your revocation arraignment hearings in your 2 probation cases. This was back on April 17th of 2024. You've already had a lawyer appointed, And your next court date in both of these cases will be a revocation arraignment and possible disposition hearing this coming Tuesday, November 25th at 8:30 in the morning in the downtown Superior Court. Your bond in each case is $500 secured. That is $1,000 total. If you bond out, comply with all of your written conditions. You have to call the probation department within 72 hours if you do bond out, and the main number is on your paperwork. If you step to your left, he'll give you that paperwork.
Thank you.
Thank you. Mr. Critchfield, and then Matthew Carbajal, we go to the chair. One second, sir. Okay. Hi, sir. Can I have your full name and date of birth?
Cole Critchfield, 6703.
All right, thanks. You're here on a probation warrant. You're on felony probation, and on August 25th, so about 3 months ago, there was a petition to revoke your probation filed. It alleges that you violated terms 3, 4, 5, and 15. You'll get a copy of it from your lawyer, and I am appointing a lawyer for you. Your next court date is in the downtown probation court on November 25th at 8:30 in the morning. That is this coming Tuesday. That'll be a revocation arraignment and possible disposition hearing. Your bond is $500. It is secured. If you bond out, comply with all of your written conditions and call your PO within 72 hours. This gentleman has your paperwork. Mr. Carbajal? And then Amber Manzueto, please go to the chair. Hello, sir. Can I have your full name and date of birth?
Matthew Carbajal, June 17th, 1988.
Okay, thanks. You're here on 2 probation warrants. You're on probation in 2 different felony cases, and on November 12th of this year, so about a week ago, there were petitions to revoke your probation filed in both cases. They allege that you violated terms 3 and 5. You'll get copies of those from your lawyer. I am appointing a lawyer for you in probation court. Your next court date there will be this Tuesday, November 25th at 8:30 in the morning. That will be a revocation arraignment and possible disposition hearing. And your bond in each case is $250 secured for $500 total. If you bond out, comply with all of your conditions and call your PO within 72 hours. You step to your left, they've got your paperwork. Thank you. All right, Ms. Manzueta, and then Denzel Van Patten, will you please go to the chair? Hello, ma'am. May I have your full name and your date of birth?
Amber Manzueta, 72788.
Thank you. You're here on a new case. You were arrested for aggravated driving under the influence of alcohol or drugs while impaired to the slightest degree. That is a Class 4 felony. There is probable cause for it, and I am appointing a lawyer for you. Your next court date will be a status conference December 4th at 8:30 in the morning in the downtown Superior Court with a preliminary hearing December 8th at 8:30. Now, initially, I was planning to give you bail based on the extremely high blood alcohol alleged and the presence of an open container of alcohol and THC vape cartridges in the car. You've got indications of long-term alcohol abuse. I've considered the information you gave pretrial as well, and what I'm going to do is release you to pretrial services with drug and alcohol testing, not a bond. And I've put it twice in your paperwork in all caps. You are not permitted to drive. You don't have a legal right. It is a crime every time you get behind the wheel of a car. So I'm releasing you, provided you agree to come to court and comply with release conditions.
Yes, Your Honor.
All right. Do you know the mandatory minimum for the crime you are accused of?
No, ma'am.
It is 4 months in the state penitentiary followed by probation. You cannot get probation until you have done 4 months in the Perryville State Women's Prison. Lucky for you, it's west of town and not like south, Arizona. But you will go to prison. No judge can lawfully give you less if you are ultimately convicted in this case. You are not convicted. You are presumed innocent, in fact, at this moment in time. They appear to have a strong case against you, though. And the reason I'm telling you that is not nearly enough people know how harsh the felony DUI sentence is. And I believe that if you know, it may incrementally protect the community by making you slightly less likely to get behind the wheel of a car and kill someone. Because thinking that drunk drivers don't kill people, it just means you've, I guess, never worked my job. I see those probable cause statements every single week. We signed DUI warrants for the entire state. Eventually, people who do this crime either kill themselves or someone else, or they hideously maim other people. So it is one of the most dangerous crimes that I IA people on. But a lot of people who commit it are sort of regular people, and they don't think of themselves as criminals. You've got a prior, you've got a real one. It's a felony. So the county attorney, if they don't want to offer you probation and you go to trial, this is also potentially prison mandatory, which just means 2.5 years presumptive. So check everything I'm telling you with your lawyer. Your lawyer will look at your criminal history. They'll look at what you're accused of. They'll look at the evidence. You can talk about contesting your case, getting the best outcome that you can. I am just hoping to professionally scare you into complying with my release orders, because I believe the safety of our community is improved if I do that. If I make you understand that right now, at this moment in time, you are staring down a prison sentence somewhere between 4 months and approximately 2.5 years. If you were to commit this same crime while this case is pending, number one, I would be obligated to hold you without bond at arrest. You would not get bond. And the county attorney would absolutely begin with a prison offer. They're not. So at this moment in time, because of your theft conviction, if you go to trial and lose, you are not probation eligible. You're not probation eligible at this moment based on my current understanding of your criminal history, unless the county attorney puts it on the table for you. And they're not going to do that if you pick up a new one or if you hurt or kill somebody. This is a very different conversation if you hurt or kill somebody. I just likely set a large bond and we don't have this discussion. The whole reason I'm having this discussion is because you haven't had the right to drive for 10 years. And there's strong evidence that you were behind the wheel of a car yesterday, drunk and high, very drunk, 0.215, wildly drunk. So drunk that it's difficult for people who aren't alcoholics to talk at a 0.215 blood alcohol. So I'm very worried about the community, yet I am releasing you. You say you have a job, you say you have 3 kids.
I do.
If you want to be out of custody while the case is pending, you must comply with these conditions. If you want to be around to parent your children, you must comply with these conditions. Whether or not you are innocent of this charge, whether or not you go to trial and win, you have to comply with these conditions, or you're going to wind up in custody, and it's a lot harder to defend your case from custody. So I both order and urge you to comply with my release conditions. Don't drive. Do you understand?
Yes, Your Honor.
All right. Everything's on your paperwork. If you step to your left, you get your people. Mr. Van Patten, and then Jade Alden, will you go to the chair? Hi. Hello, sir. Can I have your full name and your date of birth?
Good afternoon. Denzel Van Patten, 07-29-93.
All right, thank you. You're here on a new case. You were booked in on 2 allegations. I found probable cause for one of them, but not the other. The one that I did find probable cause for is aggravated driving under the influence of alcohol or drugs while impaired to the slightest degree while your license is suspended or revoked. And that is a Class 4 felony. They also booked you on the aggravated DUI that is a 3rd or subsequent DUI, but I only saw one in your criminal history, and I'm just going to double check. They did not allege a second. So that's some kind of, that's either a mistake or pre-tribs didn't find the 3rd one. So I don't see 3. I saw the misdemeanor that got your license suspended earlier this year, and now this one. So that is absolutely the elements of the Class 4 that lady has as well. So you face everything I just told her, except I think you're probably probation eligible. I don't think you have any felony priors, right? No, you don't. But if you are convicted as currently accused, and you're a long way from being convicted, so if you're like, she said I'm going to prison. I said if you're convicted, you're going to prison. You're going to do no less than 120 days in the men's penitentiary. And if you're unlucky, that'll be Southern Arizona. So that's the price for getting probation at all. And that is a very serious consequence. I think we should have it on billboards. But in any event, I'm appointing a lawyer for you. Check all of this with your lawyer. Go over everything with your lawyer about what you might face, what the evidence is against you, etc. Your status conference is going to be December 4th at 8:30 in the downtown Superior Court. Preliminary hearing December 8th at 8:30 in the same court. I'm going to release you to pretrial with alcohol testing and monitoring and strict orders written twice in your release order. Do not drive. Tell me you understand.
I understand.
All right. You do not have permission to drive from the state of Arizona, and I just prohibited you in a criminal case. There's evidence that you are dangerous when you do it. And literally, they just suspended your license earlier this year. So you can potentially go from that misdemeanor punishment, which I think was 1 day of jail, to 120 days in the men's penitentiary if you are convicted. Many people in your position get an interim, a sort of a split the baby offer from the county attorney. Talk to your lawyer about that. I don't make that offer. There's no guarantees the county attorney will make it to you. But they're not going to give you that if you pick up a new crime or pick up a DUI while the case is pending. You're also entitled to fight this case. You are presumed innocent. I'm just trying to give you a reality check to hope that you fly right and comply while the case is pending. Because I believe community safety is very much at issue in drunk driving cases. So, everything's on your paperwork. You're going to get an envelope. After you get out, call pretrial. They'll set up the alcohol testing. If you can show that you're able to stop drinking for a wide period of time, that will help your defense attorney negotiate for you. But you have to test either way. So go test. And above everything, except show up for court, don't drive. All right, if you step to your left, you get a copy of that paperwork. All right, Ms. Albin? And Counsel Sauer, I got an email from Mr. Van Horn just saying, go ahead and see her. Did you want to be heard, or can I just, this is Ms. Albin, who was the, release memo from the MCAO to MCSO. Were you appearing on hers?
I was here, but I thought the court was requesting me here.
I was, but then Tom Van Dorn sent this email saying, just do what you're going to do. Don't worry about. So you're welcome to appear. Okay, now I'm confused. Hold on 1 second, Ms. Albin. Okay.
I don't need to.
You don't need to. Okay, fine. And I'm going to explain because you deserve to know what we're talking about. All right. So, but first, let me do your hearing. So, give me your full name and date of birth. Okay.
Jade Albin, 9/14/05.
Okay, thanks. You're here on a new case.
Yeah.
You got booked in for criminal trespass in the first degree, which is a Class 6 felony. There is probable cause for it. I'm going to appoint a lawyer for you and give you a couple of court dates. That's a status conference, December 4th, which is in 2 weeks at 8:30 in the morning, with a preliminary hearing December 8th at 8:30. The address in downtown Phoenix will be on your paperwork. And you know what? I'm going to change this one, you guys. So, sorry, we got to reprint this one. Hold on. Okay, I'm going to do OR. Okay, and I'm going to release you on your own recognizance, ma'am. I'd only been planning to make you report to pretrial services anyway. But prior to court, the sheriff's office just forwarded us a note that that the county attorney had sent them saying, can you please release this person, which is a way of saying they're not going forward on the charges at this moment in time. They don't plan to. And that's something between the county attorney and the sheriff. It got forwarded to us, but nobody was requesting, well, so to make a long story short, this court doesn't just take action because somebody emailed someone else and it got sent to us. We need to be requested in a formal way to do something. We don't just, by the way, that could be forged up, down, and sideways in 2025. I don't know what anybody's authority is to just, I mean, it's like, is this person their daughter? And just, oh, hey, I can get you out of jail if I just sent whatever. And so I said to the county attorney, can you appear because MCSO is telling us you're telling them to release, and I don't know what is going on. I was going to release you anyway. You have, I think, almost zero criminal history.
I have no criminal history.
So I was going to release you anyway, by the way. So then I got an email from Ms. Sauer's supervisor saying, please disregard that memo that we sent MCSO, because it was never addressed to the court. They sent it to MCSO sent it over to us, and he said the state does not need to appear and defers to the court on release conditions. So he basically just said, don't pay any attention to that, do what you're going to do. But I will say, and there's no promises, you can't say, but the judge told me they weren't going to charge me. I will say that does raise a possibility that they're not going to charge you. And that's why I've put a phone number on your paperwork. So I'm giving you your court dates, December 4th and December 8th. I'm giving you release conditions. Do not go back to that location. Do you have things there you're going to pick up?
I was going to say, I have items there, and I was wondering if, like...
I'm going to give you it's called the civil standby. Hold on a second.
Okay.
And then I'll explain.
Because I'd like to at least get the stuff out of there and put it where I need to, where I have place to put it.
Yeah, understood. Okay. So what you have to do, and I know this is a pain in the butt, but this is how it works, is you got to call the non-emergency number for Phoenix PD and say, I need a civil standby. They will want to see your paperwork to see that I gave you permission. They'll arrange it, and they'll say, okay, come at 3 o'clock or something, and then you go over there, you grab your stuff, they keep the peace while you just pick up your stuff, and you go. And then I would say December 4th, so around about December 1st or 2nd, like the Monday or Tuesday of that week, call the number on your paperwork for court administration. It says to confirm date and time, and just give them your name and your case number and say, do I still have a court date on Thursday? It's Thursday the 4th. And if they say, no, you don't, it means the county attorney did not go forward, at least at this time. There is a 7-year statute of limitations on felonies, but they were at least initially expressing great disinterest by sending that memo. They can still go forward. It's not up to me, it's not up to you, it's up to the county attorney's office. So I'd say, but you're not going to get a good answer on whether it did actually go away until about the 1st or 2nd of December. So just call a few days in advance. That way you don't pick up a warrant if somebody on their end went, wait a minute, we do want to charge her. I have no idea what's going on over there now, but you know, I don't think you're public enemy number 100 million, and neither do they. Doesn't mean they can't charge you. So don't miss a court date in a felony case. That just guarantees you get arrested at some point in time because you didn't know. So don't lose your paperwork.
Oh, I won't. I'll be taking pictures the moment I get out and get my phone so that I have it on my phone as well.
Yeah, and then and call in and I was going to have you report to pretrial, but with this, if I think like there's a decent chance that they're not going forward, I'm not going to make you do that. If you're I'm just saying for your own good, call a few days in advance.
Yeah.
So you don't waste a trip and you don't miss any court dates, okay? All right, sounds like you definitely understand. So if you step to your left, you get your paperwork and you'll be out in a few hours. Try to be patient, it's still real slow to be released.
I've been patient.
Okay, good luck, ma'am. Oh, yeah. Okay. I think that's everybody in court. Okay, so now I'm going to do my house calls and then I'm going to do Bible and Pickens at the end. So for house calls, I've got Mr. Terrell Smith, Leslie Mescalero, and Angel Bravo. Officers, are they not physically present in court because they've been isolated by the sheriff's office as a potential risk to themselves or others?
Yes, Your Honor.
All right.
I'm not here. I do have one question for you.
Yes, ma'am.
Have you seen Joe Giverius? Is he on your docket? Have you seen him?
Daravoy? Yeah.
Yes.
Joel Daravoy? I sure did, yeah.
And you already saw him?
Yes, ma'am.
Okay. Sorry, I just came in mid-shift.
Okay, no worries.
Joel, Judge, I am here on number 5.
Number 5, okay. All right, so there's going to run some traffic. I'll make my record while I do that. All right, so Terrell Smith, number 410-1593, number 26 on the calendar. He's on a new case. He got booked in on 4 things. I only found probable cause for 1, and that is the misdemeanor of failure to admit the carrying of deadly weapon. He was also booked in on 1 allegation of possessing dangerous drugs for sale, 1 of narcotic drugs for sale. Those are Class 2 felonies. I did not find probable cause for those. He was also booked in on possession of a prohibited weapon, which I believe is a mistake at booking, but it's the wrong subsection for what they accuse him of. So there is no probable cause for that one either. I will explain that to him, let him know that I am appointing a lawyer for him. I am giving him a court date. Status conference of November 26th at 8:30, and the preliminary hearing December 1st at 8:30, downtown Superior Court. And on this misdemeanor charge, because of his criminal history, the court does believe bond remains appropriate, but only $500 secured because I did not find probable cause on any of the alleged felonies. I'll explain that to him and explain that those alleged felonies are not dismissed. And I'll give him orders not to possess any weapons nor any drugs not on valid prescription if he does post a bond. And yeah, we're going to do, and I feel like, honestly, I want to do, can we do Pickens first and then Clear again, please? Okay, yeah, Mr. Pickens, you can go ahead and come in. Are you going to be heard on this one? Counsel, did you want to be heard on Mr. Pickens? Right here, sir. All right, so give me your full name and date of birth.
Jason Pickens, July 22nd, 91.
Okay, thanks. All right, Mr. Pickens, you're here on a new case. You were arrested for child abuse, a Class 5 felony. Aggravated assault on a child, that's a Class 6 felony. Assault is a Class 1 misdemeanor, and theft is a Class 1 misdemeanor. There is probable cause for all of those, and I am appointing a lawyer to represent you. Your next court date will be a status conference November 26th at 8:30 in the morning in the downtown Superior Court, with a preliminary hearing December 1st at 8:30 in the same court. Based on what's been alleged against you, bond is set in your case at $10,000. That is secured. If you post it, you will wear an ankle monitor to keep you honest about staying away from the alleged victims. You may have absolutely no contact with the alleged victims, nor any of the children of the adult alleged victim, even if some of them are your own children. No contact with any of them. No weapons, no drugs without a valid prescription, no alcohol. If you get served with an order of protection, you have to comply with that as well. All right, that's going to be on your paperwork. Do we have that ready for him? Yes, I can. Oh, yeah, let me just double check it. Hang on 1 second. All right.
How long do I have to stay in custody?
You stay in until the bond is posted or another judge makes a different decision. You can talk to your lawyer about a motion to modify release conditions. I've also made it very clear in my paperwork, you are not to attempt contact from inside the jail either. Absolutely no contact. All right, we need to get that printed up, I guess. If you go ahead and have a seat, we will send it out to you. All right, I'm going to do one more house call record. If you can, that's going to be Leslie Mescalero, born 3/4/59. She's here on a warrant from El Centro Justice Court for third-degree criminal trespass. That's a Class 3 misdemeanor. It's a warrant, and let's see, it was issued October 31st of this year for failure to appear in a criminal trespass Class 3 misdemeanor case. So I'm going to appoint a lawyer for her on the bond question only, because it does appear this is a page 2 and she's in custody for something else. Her arraignment hearing is going to be December 4th at 8:30 in the El Centro Justice Court. Oh, I had this set up for OR. But, so, do you have her case card, Officer Leslie Mescalero, number 23? I'm just assuming that she got page 2 because she's here for something else, right?
Yes, Your Honor.
Okay, all right. I need to give her a placeholder bond, actually. So let's reprint that one. Sorry. All righty. So we give her a $50 placeholder bond because I think she's in custody on something else. And that's going to make her court date this Tuesday, November 24th. Or is that Monday? Monday, November 24th. Monday at 8:30 in the morning, the El Centro Justice Court. It's just a $50 bond because it appears to be her first FTA on this misdemeanor. And I've got release orders set up, now going to the scene of the alleged crime, et cetera, that I will go over with her. And if it turns out she is going to be released, I'll update my order to release her. Angel, are you alone in that room, sir? Okay, you can go ahead and come in.
Yes, Your Honor, he is.
Okay, thanks. All right, so you can come right here to the podium.
Good morning,
All
Your
right.
Honor.
Hello, can I have your full name and date of birth?
Joshua Carter Bible, 6/11/03.
Okay, thank you. And we lost our other DO. Okay, you can go ahead and announce, but I'm going to wait for the DO to come back.
I'm telling Sarah on behalf of the state.
Okay, thank you. Oh, okay, thank you. All right, Mr. Bible, you're here on a new case. Mm-hmm. You were booked in, and just so counsel knows, per our sort of IA rules, if it is same police agency, same DR number, we collapse them into one IA. That's how this got merged. So, Mr. Bible, you are accused of 5 total counts of sexual conduct with a minor under the age of 15. Those are Class 2 felonies and what is under the law classified as a dangerous crime against children. 5 counts of sexual exploitation of a minor, Class 2 felonies. 10 counts of, and the 5 counts of sexual exploitation was for making sexual exploitation materials. The 10 counts of sexual exploitation of a minor, Class 2 felony. There are 10 counts under the subsection that is for possessing, distributing, uploading, existing sexual exploitation materials. But that is a total of 15 counts of sexual exploitation of a minor, 1 allegation of child enticement using an electronic communications device, a Class 5 felony. The alleged offense dates for this range from September 27th of 2025 to November 18th of 2025. Based on what the police presented, the court finds probable cause for all of those allegations. I am appointing a lawyer to represent you. Your next court date will be a status conference November 26th, which is this Wednesday at 8:30 in the morning in the downtown Superior Court. Your preliminary hearing will be December 1st at 8:30 in the morning. That address will be on your paperwork. Before the court sets conditions of bail or release, what did the state want to recommend?
Your Honor, the state's recommending $250,000 cash only bond, and it posted then pretrial services with no returning to the scene, electronic monitoring, no contact with the victim or any minors, and no internet. The state is concerned over the seriousness of the allegations, that there are multiple victims, both of them 14 or younger, 14 and 13. It appears that he was trolling on Snapchat, which is where he found the first victim, which is the basis of the no internet request. The defendant also is a continuing danger to the first victim, who he knows where she lives, was actually living in the same house, and could possibly return. The state is also concerned with the content of the videos, including the ones of the victim. And so for those reasons, the state believes that he is a significant danger to the community and to minors in particular.
All right, thank you. Mr. Bible, based on what's been alleged against you, which is extensive, and the police appear to have what we would call a strong weight of evidence against you. They allege that they have admissions made in communications seized from your devices. They allege that they have videos in which both you and a child under the age of 15 are recognizable and committing sexual acts. Thus, that is the making of the child pornography. And that there are two specific victims, and that there were deliberate and repeated attempts to sexually victimize them. That the court believes what is presented strongly indicates that you have an overwhelming sexual interest in children, that you are dangerous to any and all children in the community, and very specifically these two children. There is a risk of victim intimidation or retaliation, and there is a high risk of flight to avoid prosecution, because many of the charges that you are accused of are flat time mandatory prison. Many of them are mandatory stacking. What that means is the sentences cannot run concurrently. And so that what you face is a potential for a life sentence in this case. And on these facts, the court believes that gives people a motive to flee, every bit as much as it would in a murder case. And so on that basis, and even before I saw the state's recommendation, this court was inclined to set bail in the amount of $250,000 cash only.
Is that all 250?
Correct. Cash only means dollar for dollar.
Okay.
If you post it, by law, you must be on an ankle monitor because you are accused of sexual crimes against children. And so you go on an ankle monitor. You will alcohol test to prove that you are not drinking. You may not have any alcohol. You may have absolutely no contact with anyone under the age of 18, particularly including these children. No contact with their family members, which would include their mother. You're prohibited from accessing the internet through any means except for purposes directly related to work, school, or your legal defense. You may not use any form of social media whatsoever for any reason. No weapons, no drugs without a valid prescription, no alcohol. Everything you need to know is going to be on your paperwork. If you step to your left, I'll give you a copy.
Thank you, Your Honor.
Thank you. I think that's everything, right? Okay. Good afternoon.
Thank you.
All right, I think I left off at Angel Bravo on my house call, so that's number 9. The other ones, for anybody listening, are about 5 minutes ago on this recording. All right, Angel Andres Patino Bravo, born 11/25/89, is here on a probation warrant for his Class 3 felony probation case. I am appointing a lawyer for him. I'll advise him there was a petition to revoke his probation filed October 30th of this year. It alleged that he violated terms 3 and 5. Pardon me. And so his court date will be November 25th at 8:30. I think I already said that. Downtown Superior Court. And based on, and as I said in my written order, based on the totality of what is available to know about Mr. Bravo, this court believes that he will, in all reasonable probability, be revoked to prison. And this court believes he should have been revoked to prison the last time that he violated. But he absconded instantly again from probation after his last reinstatement. He has 4 prior felony convictions and served 2 terms in ADCRR. So this court finds under Rule 7.2C that he must be held without bail in this case. I will explain that to him, and if anything changes after I conduct these initial appearances with Mr. Smith, Ms. Mescalero, or Mr. Bravo back in the cell block, I will put my final decision in my formal written order. I am not going to update this recording. All right, with that, we're going to stand in recess until 5 p.m. today. The taking of DNA and fingerprints that were given on the first calendar of this month shall apply to all matters on this calendar. I need to read a victim's rights advisement. If you are the victim of a crime with a case pending before this court, you are advised that you have rights under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, to a speedy trial, to be present at court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling and sentencing, and to receive restitution from a person who is convicted of causing you loss. If you have not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. Persons appearing before this court are reminded that they have the right to remain silent and that anything they say could be used against them. Most of you have qualified for a court-appointed attorney. If you have not qualified for a court-appointed attorney, or even if you have, you may retain an attorney at your own expense to represent you. I will be calling you up individually. When your name is called, please proceed to the podium. At the conclusion of your matter, officers will have paperwork for you. That paperwork will detail my complete orders in your case. It will also contain the dates, times, and locations of your future hearing. All right, we are going to go ahead and start this evening with Joshua Ruiz Ortiz, please. If counsel's ready for that.
Yes, Your Honor.
That was really, if you guys needed a moment, you guys can take that moment.
We just took care of it, yeah.
Okay.
Thank you.
All right. All right, Mr. Ortiz, go ahead, state your name, please.
State your name. Joshua Ruiz Ortiz.
Okay, and Mr. Ortiz, what is your date of birth?
August 24th, 2007.
All right, and on behalf of the state this evening?
Good afternoon, Your Honor. Don Sauer on behalf of the state.
And on behalf of Mr. Ortiz?
Gary Niels on behalf of Mr. Ortiz. Good evening, Your Honor.
Good evening. All right.
right. And Mr. Nielsen, will your firm be representing Mr. Ortiz going forward, or are you limiting your representation to just this initial appearance?
Our representation is limited to the initial appearance. However, we previously represented Mr. Ortiz in his juvenile matter, so I think there's a high likelihood of representation following this. But
okay, so for purposes of this case,
limited.
Okay, so when we get to that point, I am going to go ahead and, based upon the information that Mr. Ortiz provided to pretrial services, I am going to indicate that an attorney should be appointed for him.
Okay.
Of course, both you and he know that that doesn't mean that he can, of course, go on to retain you and your firm for his representation. All right. All right, Mr. Ortiz, you were arrested on charges of possession of narcotic drugs for sale, a Class 2 felony, possession of marijuana for sale, a Class 4 felony, use of an electronic communication in a drug transaction, a Class 4 felony, possession of narcotic drugs, a Class 4 felony, possession of marijuana, a Class 6 felony, and possession of drug paraphernalia, a Class 6 felony. Based on the information in the Form 4, along with the 2 Form 4 supplements that we received, I am inclined to find probable cause for those charges. However, I will hear argument first from the state and then from you, Mr. Nielsen.
Your Honor, the state's recommendation, I accidentally wrote secured on it, but the state is requesting a $50,000 cash-only bond, given the extent of drug dealing that it appears that the defendant is engaged in.
Okay, so Ms. Sauer, we'll get there. We're going to start with probable cause.
I'm sorry, Your Honor. I don't have anything to add on that.
Okay, and Mr. Nielsen?
I don't need to be heard on probable cause, Your Honor.
Okay. So based upon the information in the Form 4, together with the supplements, as I previously mentioned, I am going to go ahead and find probable cause for the charges that I listed in this matter in view of Mr. Nielsen's statement that his firm's representation is limited, at least at this time. I am going to go ahead and appoint or indicate that an attorney should be appointed for Mr. Ortiz. In Mr. Ortiz's matter, I am setting a hearing on November 26th at 8:30 and December 1st at 8:30. Both of those will be in the downtown Maricopa County Superior Court. I will now hear arguments from the parties on terms and conditions of release. And I will note with regard to this, I have reviewed the state's written recommendation in this matter. All right, Ms. Sauer, would you like to present argument?
Yes, Your Honor. The state is requesting $50,000 cash-only bond based on the extent of the evidence in the Form 4 indicating that the defendant is ongoing selling cocaine and other drugs. There's an extensive amount of evidence. It looks like he's advertising on the internet, using electronic devices. A couple things that popped out on the Form 4 is that the defendant, in messages to the officers that were working undercover, the defendant stated snow is always available, referring to cocaine, and he's mobile every day, has his cash method of payments down, only do cash or Cash App. The state is concerned for the community and the volume of drugs that it appears the defendant is dealing. And for those reasons, the state is requesting the $50,000 cash only.
All right, and Mr. Nielsen, on behalf of defendant?
Yes, I think I just first need to generally address the state's request for a cash bond. I've been noticing in my cases a shift this year that the state has been requesting a lot of cash bonds. And in the past, we had done secured bonds. And the case law is clear, the rules of criminal procedure are clear. The purpose of the bond is to secure their appearance and protect the community. when making the decision between a secured and a cash bond, that's a very big difference. That's often the difference as to whether or not someone can be released and fight their case from the outside. Because it's a lot easier to get the secured on $50,000, for example, than to find anyone to put up $50,000 of cash. Bail bondsmen often aren't willing to do that large of an amount because they need capital in order to keep their liens going and everything. I'm sure the court is fully aware of those factors, and it is something that the court must consider under Rule 7 because the defendant's ability to pay is grounds for modification in the future. So I'm seeing a lot of cases that are set cash, and then we're immediately doing motions to modify, which are granted because they just are far too onerous for what we'd expect. $50,000 cash bond in a case where someone has been injured, someone has shown that they're violent, someone has shown they're a threat to the community, and there's doubt as to whether or not they can control themselves, yeah, $50,000 might be sobering. When you have a kid that is advertising on Instagram, and we have two things. We have a small amount of cocaine that is found, very serious, I'm not trying to minimize that, but then the rest of the products are THC-related products that if he were a smoke shop, he would have every right to sell. He has no right to sell them. He has, felonies, allegedly has no right to sell them, right? That has felonies that reflect that. I think the fact that he has 6 pending felonies is going to be sobering enough to protect society at large and make sure that he's not running around doing this. I also want to know that on the form that I received, it says he has a prior conviction for aggravated assault. That's simply incorrect. We had his juvenile case because it is a juvenile delinquency and is sealed. I can't actually comment as to the outcome of the case, but I will avow to the court that it is incorrect that he has a prior conviction for aggravated assault. He does not. So I would ask the court to not consider that in making its decision. So as far as what we think is appropriate, we would ask for him to be released to pretrial services, but if the court is inclined to issue a bond, it should be a secured appearance bond, and I think it should be indicative of either the cash or the value of the goods that were collected. I don't know why we'd be doing a cash bond that is many, many, many times the value of the drugs that he was actually found with. I think if he is released to pretrial services, having worked with him before, and our firm having worked with him before, he will have good contact with counsel. Even if he's assigned counsel and doesn't ultimately represent us, he will take this very seriously. And the fact that he has all of these felonies hanging over his head and understands now the severity of the situation he is going to be enough to keep him both coming to court and on the straight and narrow while he's out and about. This is not a violent offense. No one was injured during the offense, so that the only real risk to the community is the court assessing whether or not they think if upon release he's going to go around trying to sell drugs on Instagram. I think that's highly unlikely given the severity of the situation he's in. So for those reasons, we would ask for release to pretrial services, but if the court is inclined to issue a bond, it should be a secured appearance bond. Thank you, Your Honor.
All right. Having heard the argument of counsel, I'm going to go ahead and set a secured appearance bond in this matter in the amount of $25,000. I think I hear counsel's argument about that this was a nonviolent offense. However, I am also very cognizant about the volume of sales or potential advertised sales that were alleged in the Form 4 and the potential risk that puts the community in. There are certain transactions in which marijuana is legal. However, this was not one of them, and cocaine is illegal for a reason. It's illegal because of the danger it presents to the community. As a result, I think that a secured appearance bond in the amount of $25,000 is appropriate in this case. I'm also going to order pretrial services to include electronic monitoring. If I am going to put a secured appearance bond on Mr. Ortiz, I think electronic monitoring is appropriate to go with it. It has not been asked, but I am going to order that he not have any contact with any co-defendant. I understand from reading the Form 4 that he was involved with another individual, and he should not be having any contact with that individual. Following up on the state's recommendation, prohibit him from accessing the internet, I do agree that that's appropriate, again, given the illegal means for which he was using or allegedly using the internet. So he may only access the internet for school, work, and court purposes. He may not possess any weapons, no drugs without a valid prescription, and no alcohol. These are all true because they're part of my release conditions in this case, but also due to his age. All right. Anything further from the state, Ms. Sauer?
No, Your Honor, thank you.
Anything further from you, Mr. Nielsen?
No, Your Honor, thank you so much.
All right, we're going to go ahead and get that paperwork printed up for you.
Thank you. You want to talk to her? Yes.
All right, are you here on any other cases, Ms. Sauer?
Not unless you want me to be.
Hold on just a second. No, I think I'm good. I just saw your updated recommendation on number 7. So I will review that and we'll get that uploaded in part of the case.
Okay, great, thank you.
Thank you.
Have a good night.
All right, Judith Figueroa, please, and then Ashley Sen. All right, Mr. Figueroa, go ahead, state your name, please.
Judas Alexis Figueroa.
Mr. Figueroa, what is your date of birth?
May 31st, 2005.
Thank you. All right, sir, you are here this evening on 2 matters. We are going to go ahead and talk about, give me a second. They're both failures to appear. All right, we're going to talk about your 23 case, and we'll talk about your 25 case. All right, you are here in your 23 case because Maricopa County Superior Court issued a warrant for your arrest based upon your failure to appear in your case CR 2023-131886. In that matter, I'm not appointing you an attorney because if you were entitled to have an attorney appointed, one should already have been appointed for you. I am setting a hearing. You can always retain an attorney at your own expense to represent you. I am setting a hearing on November 26th at 8:30 in the downtown Maricopa County Superior Court. In your 23 matter, I am setting a secured appearance bond in the amount of $50. Now, you are also here because the Maricopa County Superior Court issued a second warrant for your arrest based upon your failure to appear in your case CR 2025-126406. In that matter, once again, I am not appointing you an attorney because if you are eligible to have an attorney appointed, one should already have been appointed for you. You can always retain an attorney at your own expense to represent you. I am setting a hearing on November 26th at 8:30 and December 1st at 8:30, both in the downtown Maricopa County Superior Court. In your matter, however, because your presence here was obtained by means of a writ, I am holding you non-bondable in your 25 case. Okay. All right, go ahead, step to the left. Officers have your paperwork. Ashley Sin, please. And then Woody Williams. All right, Ms. Sin, go ahead, state your name.
Ashley Ronique Sin.
And Ms. Sin, what is your date of birth?
August 22nd, 1983.
Thank you. All right, ma'am, you are here this evening on two matters. We're going to go ahead talk about your 26 matter first, and then we'll talk about your 25 matter. All right, you are here because the Maricopa County Superior Court issued a warrant for your arrest based upon allegations that you violated your probation in your case CR 2016-001232. In that matter, I am appointing you an attorney, and I am setting hearings on November 25th at 8:30 in the downtown Maricopa County Superior Court. In your 2016 matter, I am setting a secured appearance bond in the amount of $500. Now, you are also here because the Maricopa County Superior Court issued a warrant for your arrest in a second case. This one's also based upon allegations that you violated your probation in your case CR 2025-100023. In that matter, I am appointing you an attorney, and I am setting hearings on November 25th at 8:30 in the downtown Maricopa County Superior Court. In your 25 case, I am holding you non-bondable because your appearance in this matter was secured through a writ, and you remain in the primary custody of the U.S. Marshals Service. Okay? Go ahead, step to the left. Officers have your paperwork for you. All right, Woody Williams, please, and then Joseph Fenrick. All right, Mr. Williams, go ahead, state your name.
My name is Woody Williams.
And Mr. Williams, what is your date of birth?
12/25/79.
Thank you. All right, sir, you are here this evening because Maricopa County Superior Court issued a warrant for your arrest in a direct complaint matter. That direct complaint alleges that on or about June 8th of 2024, you committed the offense of aggravated driving or actual physical control while under the influence of intoxicating liquor or drugs, a Class 4 felony. There are 2 counts of that. I am appointing you an attorney, and I am setting hearings on November 26th at 8:30 and December 1st at 8:30. Both of those will be in the downtown Maricopa County Superior Court. In your matter, and pursuant to that direct complaint arrest warrant, I am setting a secured appearance bond in the amount of $15,000. In the event you are able to post that bond and secure your release, you would be subject to certain release conditions, including alcohol and drug testing. All right, go ahead, step to the left. Officer has your paperwork for you. All right, Joseph Fenrick, please.
Thank you.
All right, Mr. Fenrick, go ahead, state your name.
Hello?
Can you state your name, please?
Joseph Fenrick.
And Mr. Fenrick, what is your date of birth?
8/18/1965.
All right, sir, you are here this evening on 3 matters. We're going to talk about your new matter first, and then we'll talk about your other cases. All right, so you are here because because you were arrested on charges of possession of dangerous drugs, a Class 4 felony, and possession of drug paraphernalia, a Class 6 felony, and you were arrested on those charges yesterday. On your new charges, I am appointing you an attorney, and I'm setting hearings on November 26th at 8:30 and December 1st at 8:30. Both of those will be in the downtown Maricopa County Superior Court. On your new charges, I am setting a secured appearance bond in the amount of $50. All right, now you are also here because you are currently on probation in your case CR 2024-000790. In that matter, your new charges for which you were arrested yesterday would constitute an alleged Term 1 violation of your existing probation.
What's that?
Huh?
What's that?
What is that? So Term 1, in Term 1, you agree, as part of your probation, you agree to obey all laws, all criminal laws. Hold on. We'll tell you exactly. So Term 1 of your probation requires that you it says, I will obey all criminal laws. All right, that's why the charges for which you were arrested yesterday would constitute an alleged Term 1 violation of your existing probation. In your existing probation case, I am appointing you an attorney, and I am setting hearings on November 25th at 8:30 in the downtown Maricopa County Superior Court. I'm also setting a secured appearance bond in the amount of $250.
Okay, so I was trying to find out, so the $50, there's a bond of $50?
For your new charges, yes.
And then there's a bond of $250.
In your probation case.
Okay.
And then we still have one more case to talk about, okay? All right. So the grand jury in Maricopa County the grand jury in Maricopa County issued a warrant for your arrest based upon the following violations. That on or about May 20th of 2025, you committed the offense of aggravated assault, a Class 3 felony, and that on or about that same date, you committed the offense of disorderly conduct, a Class 6 felony. In that matter, I am appointing you an attorney, and I am setting a hearing on November 26th at 8:30 in the downtown Maricopa County Superior Court. In that matter, I am setting a secured appearance bond in the amount of $10,000.
$10,000?
Yes, sir. All right, in the event you are able to post your bonds and secure your release, you would need to contact your probation officer within 72 hours. If you are still in custody on the dates of your hearings, you will be transported. All right, go ahead, step to the left. Officer has your paperwork for you.
What do you want me to do?
Oh, they have your paperwork for you right there, sir.
Let me go ahead and take a seat now.
All right, Raul Rodriguez Sanchez, please.
Hello, ma'am.
Hi. All right, sir, go ahead, state your name.
Raul Rodriguez Sanchez.
And Mr. Rodriguez Sanchez, what is your date of birth?
September 21st, 2007.
Thank you. All right, sir, you are here this evening because you were arrested on 2 counts of burglary in the 3rd degree, a Class 4 felony. I did find probable cause for both of those. I am appointing you an attorney.
Yes,
I am setting hearings on November 26th at 8:30 and December 1st at 8:30. Both of those will be in the downtown Maricopa County Superior Court.
I have a question. Can I ask?
Yes, sir.
So if I was out on bond already and like they rearrested me for old charges, because like how does that work? Because I was out on bond and they just rearrested me for old charges, for these 2 new charges.
So you are currently on release in your case CR 2025-004006. That's a separate case from these charges for burglary, these two counts of burglary in the 3rd degree, for which I'm seeing you this evening.
So like, can I still get on bond, or how does that work?
So the answer is yes. So this evening, I am appointing you an attorney. I'm setting hearings on November 26th at 8:30 and December 1st at 8:30. Both of those will be in the downtown Maricopa County Superior Court. In this matter, I am setting a secured appearance bond in the amount of $5,000. In the event that you are able to post that bond and secure your release, you may not return to the scene of the alleged crime or any contact with any alleged victim. You're also not having any contact with any co-defendant, okay?
Co-defendant would.
So according to the Form 4, you engaged in these activities with at least one other person, these allegedly illegal activities. Those folks would be your co-defendants,
yes,
okay?
ma'am.
Or potentially be your co-defendants.
Yes, ma'am.
All right, no weapons, no drugs without a valid prescription, and no alcohol.
So how much do I gotta pay, like, to get out?
So you can work with it as a secured appearance bond. You can work with a bond company to post that bond. How much they require as their fee depends on you and your individual circumstances. It depends on the bond company you're working with. Most of them charge about 10%, but again, it depends on a variety of factors.
So, like, okay, so if I paid 10% be what? 500?
Okay, I'll tell you what, why don't you go ahead, step to the left, get your paperwork, and if you have those questions, the bond company is really the person, the entity you need to talk to, okay?
All right, appreciate it.
All right, Cecil Smallwood, please. All right, sir, go ahead and state your name.
Cecil Smallwood, 12-2-70-71.
Okay. All right, sir, you are here this evening because you have been charged with, there have been additional charges submitted in association with.
Is it additional or?
Additional in association with the incident on or about November 18th of 25.
I thought they just changed the number on it. That's what they told me earlier today.
Okay. Well, so these are additional charges.
Okay.
All right. So this evening, so the additional charges are aggravated assault, victim bound or restrained. That's a class 4 felony. I did find probable cause for that. Based upon the information that you've provided to pretrial services, I am finding that you are not indigent for purposes of appointing you an attorney, so I am not appointing you an attorney this evening. You may, of course, retain an attorney at your own expense to represent you. I am setting hearings on November 26th at 8:30 and December 1st at 8:30. Both of those will be in the downtown Maricopa County Superior Court. In your on these additional charges, I am setting a secured appearance bond in the amount of $5,000. In the event you are able to post that bond and secure your release, you would be required to participate in pretrial supervision to include alcohol and drug testing as well as electronic monitoring. You may not return to the scene of the alleged crime or have any contact with the alleged victim or any complainant or witness. No weapons, no drugs without a valid prescription, and no alcohol. Also going to need to obey the terms of any order of protection that has been issued or may be issued. You may not reside at the same location as any alleged victim or go to the alleged victim's residence. This is consistent with your previous release order. Even if you are an owner or renter of the residence, if you presently reside with any alleged victim, you must find an alternative residence. You can arrange for one civil standby with law enforcement to collect any essential belongings.
Okay. So what is my total bond?
So for the cases, so for the first two charges, based upon the first two Maricopa County Superior Court charges, based upon this incident on or about November 18th of 25, it looks like when you saw the commissioner on the 18th, that a secured appearance bond in the amount of $20,000 was set.
Let me ask you a
question.
question.
And then now I'm
Another $5,000.
Another $5,000.
Okay, so let me ask you a question. If I can't get out, how do I get a lawyer?
So if you can't get out,
because I don't know anybody here. I'm not from Arizona.
Okay, so if you can't get out, you will be transported to your hearing. So that's how you'll get to your hearing. As to how you get in touch with attorneys, I think that officers should be able to get you contact information. I think the bar has a referral service.
I don't even have no way to get to my money or anything. I have nobody out there. Right. So I mean, what I told pretrial is what I have out there, but if I can't get to it, I can't.
Okay. So officers should be able to provide you with information regarding logistics. All right, LaShawn Vaughn, please, and then Corinne Werner. All right, sir, go ahead, state your name.
Sean Vaughn.
Mr. Vaughn, what is your date of birth?
10/6/84.
All right, sir, you are here this evening because you were arrested based upon charges of unlawful control of a means of transportation, a Class 5 felony, and criminal trespass in the 3rd degree, a Class 3 misdemeanor. I did find probable cause for both of those. I am appointing you an attorney. I am setting hearings on November 26th at 8:30 and December 1st at 8:30. Both of those will be in the downtown Maricopa County Superior Court. In this matter, I am setting a secured appearance bond in the amount of $5,000. In the event you are able to post that bond and secure your release, you would be subject to certain release conditions, including electronic monitoring. You may not return to the scene of the alleged crime or have any contact with any alleged victim. You are not to possess any weapons, no drugs without a valid prescription, and no alcohol. Okay? Go ahead, step to left. Officer has your paperwork. All right, Corinne Werner, please, and then Corey Ingalls. All right, ma'am, go ahead, state your name.
Corinne Warner,
And Ms. Werner, what is your date of birth?
6/9/1987.
Thank you. All right, ma'am. Just a second. All right, you are here this evening because the Maricopa County Superior Court issued warrants for your arrest based upon your failure to appear in your cases CR 2018-129519 and CR 2025-130815. In both of those matters, I am not appointing you an attorney this evening because if you were entitled to an attorney, one should already have been appointed for you. You can always retain an attorney at your own expense to represent you. I am setting hearings on November 26th in both cases at 8:30 in the downtown Maricopa County Superior Court. In your 2018 case, I am setting a secured appearance bond in the amount of $2,500. And in your 25 case, I am also setting a secured appearance bond in the amount of $2,500. In the event you are able to post those bonds and secure your release, I am reminding you, you are on probation, so you would need to contact your probation officer within 72 hours. All right, go ahead, step to left. Officers have your paperwork. Corey Ingalls, please, and then David Lutch.
Right here.
Right there. All right, sir, go ahead, state your name.
Corey J. Ingalls.
And Mr. Ingalls, what is your date of birth?
04/22/1996.
Thank you. All right, sir, you are here because you were arrested yesterday on charges of unlawful flight from law enforcement, a Class 6 felony. I did find probable cause for that.
Which is wrong because I
am appointing you an attorney.
Okay.
So whatever defenses you may have, sharing those with your attorney, talking to your attorney about those is what you would need to do. I'm finding probable cause based upon the information in the Form 4. All right, I am setting hearings on November 26th at 8:30 and December 1st at 8:30. Both of those will be in the downtown Maricopa County Superior Court. I'm also setting a secured appearance bond in your matter in the amount of $2,500.
What's the secured appearance bond?
It means you can work with a bond company in order to get that bond posted.
What does bond posted mean? So that I'll be stuck here until I can figure out that payment?
Yes, sir.
Is there any way that we can see, because I'm not guilty of this, because there's been no reason. I've never fled from the police, ever. I've always stopped. I know this for a fact, and I do not have the funds to be able to do that because right now, currently, I am working on a business. I literally just started up a company. I am staying with my grandma and providing for her and her animals currently. And, I mean, I'm not going anywhere. I don't know how she'd be able to get food how to feed her animals. I was providing for her.
Okay.
I was working, I was doing odd jobs, and...
All right. So detention officers will have information about bond companies that are available If in the event you are not able to post that bond, then you will remain in custody at least until your first hearing on November 26th. In the event you are able to post that bond and secure your release, you would be subject to certain release conditions, including electronic monitoring. All right?
Okay, so for terms to go about this, I would really like for you to reconsider on grounds of there is no evidence that I was even running from the police.
Okay, so the car that fled from the police was the...
Supposedly fled.
Allegedly fled from the police was the car that you allegedly drive in and that you are the only person to allegedly drive.
I currently do not have that vehicle.
Okay, so based on the information in the Form 4, like I said, I am finding probable cause. Based on that probable cause, I think a bond in this case is reasonable. Go ahead, step to the left.
We have paperwork for you right there. Go ahead, take a seat to the left of there.
David Lutch, please, and then Brian Whitman. All right, Mr. Lutch, go ahead, state your name.
David Lucht.
Sorry about that. Mr. Lucht, what is your date of birth?
9/7/94.
Thank you. All right, sir, you are here on 3 matters. We're going to go ahead and talk about your new case first, then we'll talk about your probation case. All right, you are here because you were arrested yesterday on charges of possession of narcotic drugs, a Class 4 felony, possession of drug paraphernalia, a Class 6 felony. I did find probable cause for both of those. I am appointing you an attorney. I am setting hearings on November 26th at 8:30 and December 1st at 8:30. Both of those will be in the downtown Maricopa County Superior Court. On your new matter, I am setting a secured appearance bond in the amount of $250. Now, you are also here because you are currently on probation, and your case is CR 2019-153259 and CR 2021-130403. In those matters, your new charges for which you were arrested yesterday would constitute a violation, an alleged Term 1 violation of both of your probations. In your 2019, in both of your probation cases, I am appointing you an attorney, and in both of your probation cases, I am setting hearings on November 25th at 8:30 in the downtown Maricopa County Superior Court. In your 2019 case, I am setting a secured appearance bond in the amount of $1,000. In your 21 case, I am setting a secured appearance bond in the amount of $500. In the event you are able to post your bonds and secure your release, I am reminding you, you are on probation, so you would need to contact your probation officer within 72 hours. All right, go ahead, step to left.
Well, what about my 2 cases, my misdemeanor cases?
So your misdemeanor cases are being heard in, assuming you have them, they're not on my docket, they're not on my calendar. So they would be being heard in a justice or municipal court. Do you know, officer?
He doesn't have any other except for the ones that you went over.
Okay.
I have 2 failure to appears. That's the only reason that I was stopped.
Okay. Hold on, let me, maybe.
I'm just trying to find out my total bond amount, because I know I have 2 $500 bonds on those.
Okay, hold on. Do we know if Mr. Lucht is on an additional calendar other than this one?
But I still would have to pay those bonds.
So if you were arrested on those warrants for failure, you're telling me they're failure to appear. I don't know that. You will likely go before a judicial officer to be heard, and that judicial officer will review those warrants and then make a decision.
When will that be?
I don't know, because I don't have any information regarding those warrants in front of me, okay?
Okay.
Brian Whitman, please, and then Bruno Cisneros.
Yes, Your Honor.
All right, sir, go ahead, state your name.
Brian Mark Whitman.
And Mr.
Yeah.
Oh, sorry, go ahead.
10793, excuse me.
No, you knew where you were going. All right, I just need to get out your way.
Good.
All right, sir, you are here because the Maricopa County Superior Court issued a warrant for your arrest based upon allegations that you violated your probation in your case CR 2024-142781. In that matter, I am appointing you an attorney, and I am setting hearings on November 25th at 8:30 in the downtown Maricopa County Superior Court. In the probation violation matter, I am setting a secured appearance bond. However, my review of your matter is that you are currently in DOC on a different matter.
Yes, Your Honor.
Okay, so even if you were to post this bond, you would still remain in DOC custody, or you would still remain in custody because of your other matter?
Yes, Your Honor.
Okay. All right, go ahead, step to the left, officer has your
thank you.
paperwork. Bruno Cisneros, please, and then Helena Wilkinson. All right, Mr. Cisneros, go ahead, state your name.
Bruno Cisneros,
And Mr. Cisneros, what is your date of birth?
11/21/62.
Thank you. All right, sir, you are here this evening because the West Mesa Justice Court issued a warrant for your arrest. This is a post-adjudication failure to pay warrant stemming out of a 2018 charge of driving with a suspended or revoked license. Now, before we get much further, give me a second. Are you in custody on a different case in a different matter, or just this one?
Just this one.
Okay, she's going to confirm that for me.
Just this one.
Just this one. Okay. All right. I'm going to update this. Give me just a second, Mr. Cisneros. All right, let me back up. All right, due to the nature of those charges, or of the, due to the nature of your case, you're not entitled to have me appoint an attorney for you this evening. However, you may, of course, retain an attorney at your own expense to represent you. I am setting a hearing on December 9th at 8:30 in the West Mesa Justice Court. Will you go to that?
Yes.
Then based upon your promise to appear, I'm going to go ahead and release you this evening on your own recognizance. All right, we did update your paperwork, and the officer has that for you if you want to go ahead. Step go up.
Yeah.
All right, Helena Wilkinson, please. All right, just a second. All right, ma'am. Go ahead, state your name.
Helena Wilkinson.
And Ms. Wilkinson, what is your date of birth?
060201.
All right, ma'am, you are here this evening because you were arrested yesterday on 2 counts of possession of narcotic drugs, class 4 felony, and 1 count of possession of dangerous drugs, class 4 felony, and 1 count of possession of drug paraphernalia, a class 6 felony. I did find probable cause for all of those. I am appointing you an attorney. I'm going to ask you a question. You don't have to answer me. But based upon my review of your case, I believe that you are also in custody because of a parole matter. Is that correct? Is that a yes?
Yes.
Okay. All right. So I'm going to go ahead and set hearings on November 26th at 8:30 and December 1st at 8:30. Both of those will be in the downtown Maricopa County Superior Court. On your new charges, I am setting a $50 secured appearance bond. In the event you are able to post that bond and secure your release, hold on. I need to fix this one. Sorry, Karina. All right. I'm going to fix it. I am reminding you, because you are on parole, you would need to contact your parole officer within 24 hours.
I wouldn't get out.
I'm sorry, what?
I wouldn't get out even if I posted it.
Okay. I understand that.
You said it's $50?
$50. So my intention here is, because based upon my information, you have a parole hold on you, which means you're going to be in custody on your parole matter. My intention is, by placing that $50 secured appearance bond, is to give you credit for time in custody in this case.
It is to what?
Give you credit for time in custody in this case. If you're going to be here anyway, you should be able to get credit for time in custody.
So if I have money on my like if I got brought in with money, can I pay that with that?
So even if you post bond on this case, you're still in custody in your other case.
I know, but so time served, you said time served, right?
Well, you could get credit for time in custody in this matter, which is why I'm placing that $50 secured appearance bond. But
Okay.
even if you post your bond in this matter, you would still be in custody in your other matter.
Okay.
Okay. All right. Officer has your new paperwork. Go ahead, step the left. All right. Dreamer Vincenti Veneno. Hi. All right, sir. Go ahead. State your name.
Dreamer Venino,
And Mr. Venino, what is your date of birth?
11/19/2000.
Thank you. All right, sir, you are here because you were arrested earlier today on charges of criminal trespass in the first degree, a Class 6 felony. I did find probable cause for that. I am appointing you an attorney, and I am setting hearings on December 4th at 8:30 and December 8th at 8:30. Both of those will be in the downtown Maricopa County Superior Court. Will you go to those?
Yes.
And based upon your promise to appear, I'm going to go ahead and release you on your own recognizance this evening. You may not return to the scene of the alleged crime, okay?
All right.
And not have contact with any alleged victim, complainant, or witness, all right?
Okay.
All right, go ahead, step to the left. Officer has your paperwork.
Thank you.
All right, Jason Reese, please, and then Zador Pingree. All right, sir, go ahead, state your name.
My name is Jason Reese,
And Mr. Reese, what is your date of birth?
3/27/84.
Thank you. All right, sir, you are here this evening on two matters, and we're going to go one by one. All right, you are here because the Country Meadows Justice Court issued a warrant for your arrest. This is based upon your failure to appear in your matter stemming out of an August 5th, 2025 charge of possession of an open container in vehicle. Because of the nature of those charges, you are not entitled to have me appoint an attorney for you this evening. However, you may, of course, retain an attorney at your own expense to represent you. I'm setting a hearing on December 4th at 8:30 in the Country Meadows Justice Court. Will you go to that?
Yes, ma'am.
Then, based upon your promise to appear, I'm going to release you on your own recognizance in this matter. All right, now you are also here because... Wait, hold on. The Peoria Municipal Court issued a warrant for your arrest based upon your failure to appear in connection with an urban camping charge. Again, based on the nature of those charges, you're not entitled to have me appoint an attorney for you this evening. However, you may, of course, retain an attorney at your own expense to represent you. I'm setting a hearing on December 9th at 9 a.m. in the Peoria Municipal Court. Will you go to that?
Could I get them both together, like next to one another?
Well, because one of them is in the country. The answer is no, for two reasons. One, they're in two different courts.
Okay.
And two, I can't change the dates.
Okay.
All right? So will you go to this one in Peoria Municipal Court?
Yes, ma'am.
All right, and based on your promise to appear, I'm going to release you on this one on your own recognizance. Officer has your paperwork. If you don't go to the hearings, another warrant may issue for your arrest, okay?
I'll be there, Your Honor.
All right, go ahead, step to the left. Officer has
Your
your
Honor.
paperwork. All right, Zador Pingree, please. All right, sir, go ahead, state your name.
Zader Pingree,
All right, Mr. Pingree, what is your date of birth?
August 22nd of 2001.
Thank you. All right, sir. Just a second. They give that big white laminated card. There you go. All right. Hold on. All right. All right, sir, a warrant for your arrest has been issued by the state of Texas. That state wants you back on the warrant. Before court, you were given some paperwork to review on a big white laminated card. That's the card we just talked about. Did you read that paperwork?
Yes, ma'am.
Okay. All right, and as I stated, you have a warrant from the state of Texas. You have a choice to make at this time. You can choose to waive your right to an extradition hearing and be sent back to the requesting state within 30 days, or you can demand an extradition hearing and that a governor's warrant be signed by the governors of both states, that's Texas and Arizona, before you are sent back to the state of Texas. If you choose to waive your right to an extradition hearing, you would be held non-bondable in Maricopa County Jail for a period of up to 30 days to allow time for the requesting state to come for you. That 30 days would start tomorrow, as long as you do not have any criminal charges pending against you anywhere in Arizona. If you do have criminal charges pending against you in Arizona, the 30-day period would not start until those charges are resolved. If you choose to have an extradition hearing, I will set your hearing for December 1st at 1:30 p.m. in the downtown Maricopa County Superior Court. I cannot appoint an attorney to represent you because extradition matters are civil in nature, but you would have the right to hire a lawyer at your own expense if you choose. You are not entitled to bail in this matter because the arrest warrant is for a alleged parole violation. A governor's warrant signed by the governors of both states is required to extradite you to Texas. That process could take up to 90 days. So you need to let me know at this point whether or not you want to waive your right to an extradition hearing or whether you want to keep that extradition hearing on December 1st at 1:30.
That's a big choice.
It is, and if you don't, I mean, if you want to think about it between now and December 1st, you can certainly do that. However, because this is a warrant for a alleged parole violation, you will be held non-bondable.
And I don't got no charges out of Arizona, right?
I don't know that. You have this. You are on my calendar only for this matter, but I don't know what other charges may be pending against you.
So to waive it means I leave in 30 days? Like they'll come get me in 30 days?
It means that Texas has 30 days to come for you, yes.
And if they haven't came and got me in 30 days, then what?
30 days would start tomorrow as long as you don't have any charges pending against you in Arizona. And if they don't come for you in 30 days, then you would, I think there's a way to extend it. They can request it to be extended by a few days, but then you would be released.
All right.
However, you could be rearrested because the warrant's still valid.
Right. So that's if I waive it.
If you waive it, yes, that is if you waive it.
So if I waive it, they got 30 days, right?
Yes, 30 days from tomorrow, again, subject to not having any cases pending against you in Arizona, and they can extend it by a few days.
All right, I'll waive it.
All right. Okay. All right, so now we have to go through some information. If you've ever done a plea agreement, this is a lot like that, okay? I understand at this time you do want to sign the waiver of extradition. I need to ask you some questions as I am making a record of the proceeding. Did you read the waiver of extradition paperwork?
Yes, ma'am.
Do you understand that you do not have to sign the paperwork?
Yes, ma'am.
Do you understand that you have the right to an extradition hearing?
Yes, ma'am.
Okay. Do you understand that you have the right to hire a lawyer at your own expense?
Yes, ma'am.
Do you understand that you have the right to demand that a governor's warrant be signed by the governors of both states before you are returned to Texas?
Yes, ma'am.
All right. Do you want to give up those rights and sign the paperwork?
Yes, ma'am.
Okay. Has anyone threatened you or promised you anything to get you to sign the paperwork?
No, ma'am.
Okay. Have you had any drugs, alcohol, or medication within the last 24 hours?
No, ma'am.
I find that you knowingly, intelligently, and voluntarily are signing the waiver, and I am also signing it. I am directing the sheriff's office to notify Texas that you are ready to return. Texas will have 30 days from tomorrow to pick you up unless there are local charges pending. If there are local charges pending, the 30 days will not start until the conclusion of that case. Do you have any questions?
No, ma'am.
All right. Second. All right. All right. I have completed my portion.
And then if you want, you can just step on the list. There should be a signature pad at the bottom. You're going to send twice. You can go ahead and hand it first. Sign again.
Perfect. Thank you.
And you're all set.
All right, we need to clear him.
He'll go to
All right, Brian Ariola, please. All right, sir, go ahead, state your name.
Brian Nicole Ariola,
And Mr. Ariola, what is your date of birth?
August 17, 2007.
Thank you. All right, sir. You are here because an additional charge of indecent exposure, a Class 1 misdemeanor, has been filed against you. So now instead of having one count, this is the second count of indecent exposure. It's also a Class 1 misdemeanor. In this matter, I am appointing you an attorney, and I am setting a hearing on November 25th at 8:30 in the West McDowell Justice Court. On your new charges, on your new charge, I am setting a secured appearance bond in the amount of $50. Okay, so that's in addition to the bond that I set yesterday when I saw you. All right. In the event that you are able to post that bond and secure your release, you're not to return to the scene of the alleged crime or have any contact with any alleged victim, complainant, or witness. All right?
Okay.
Do you have any questions?
No, thanks.
All right, go ahead, step to the left, authorize your paperwork. All right, we have 2 house calls this evening. Our house calls are not able to be with us this evening because they are a danger to self, a danger to others, or otherwise not able to function for purposes of being with us in court this evening. All right, our first house call is David Villegas. Mr. Villegas' date of birth is July 23rd, 1992. Mr. Villegas is here because he was arrested earlier today on charges of aggravated DUI, a Class 4 felony. I did find probable cause for that. I am appointing him an attorney. I am setting hearings on November 26th at 8:30 and December 1st at 8:30. Both of those will be in the downtown Maricopa County Superior Court. On Mr. Villegas's DUI charges, I am setting a secured appearance bond in the amount of $1,500. In the event he's able to post that bond and secure his release, he would be subject to alcohol and drug testing. Now, Mr. Villegas is also here because the Tolleson Municipal Court issued a warrant for his arrest. This is a post-adjudication failure to pay warrant. In this matter, I am appointing an attorney for him, or am indicating an attorney should be appointed for him in his next hearing, which will be at the Tolleson Municipal Court on December 1st at 8:30. That attorney is being appointed for limited representation regarding the bond issue only. I am setting a $50 secured appearance bond in that matter. Our next house call is Roy Shemp. Mr. Shemp's date of birth is January 24th of 1980. Mr. Shemp is here because the West Mesa Justice Court issued a warrant for his arrest based upon his failure to appear in his matter with that court. In that matter, I am appointing him an attorney, again, for limited representation regarding the bond issue, only because I am setting a $250 secured appearance bond in that case. I'm also setting a hearing on November 25th at 8:30 in the West Mesa Justice Court. All right, that brings us to the end of our 5 p.m. initial appearance calendar, and we're going to go ahead and stand adjourned until 8, and we are off the record.